for that. All right. Welcome back. Second and last hour on the topics of today. On this slide, we see some hints to the regulatory framework legal rules that are determining the co-determination theme of prior to the coffee break. And one of these examples is from the European Union, where in an attempt to harmonize work conditions in the European Union, there's a regulation that basically makes work councils a European supranational, also called federal affair. So that there is no voluntarism in the individual member states where it comes to work councils. But obviously, European legislation is a compromise between stakeholders within the European Union, and one of the advisory constitutional organs in the European Union is the so-called Social and Economic Council. And such piece of legislation is heavily influenced by that council, which you discussed in the course on European law, which is the least sexy organ in Brussels, but quite important, because that is along the tradition of the Netherlands and Germany and Denmark and a few other countries, a council in which employers, employees, and state representatives are working together. So there the compromise between the interest of enterprises and workers is already pre-cooked, and this piece of legislation is not the most extreme version. It's sort of laying a minimum standard, have a council, and at least provide them with information. Because with information you can already start to plan strikes or other inconveniences. Let's take the next step, and a step lower or more away from corporate law and deeper into labor law as a non-corporate law solution to the misery of employers or employees. And and that strategy, which is basically a rules strategy, quick and dirty rules pertaining to dismissal, for instance, are in each country different, but a little bit similar in outcome, and in each country, including the Netherlands, subject of heated debates on the design of such a dismissal procedure. Should it be a judge? Should it be a expert? Should it be a mediator? Should it be, you know? And every political decade brings a new chapter in that debate. But since 1946, 47, 48 in the Netherlands, whatever changes were made, there was always at the end of the road a judge. And that is the example on the slide, where the judge, Article 671C, is still allowed, whatever other procedure exists, to dissolve the labor agreement. So labor law basically says if you enter into a permanent labor agreement, there is no end unless a judge cuts the ties. A little bit similar to marriages. You're married, and only a judge ruling can end that. And that is sort of the most extreme safeguard of any jurisdiction, to involve this expensive and time-consuming state official called a judge. Yeah? We only have 1,200 judges in the Netherlands. So if a piece of legislation channels human beings to a court, that's quite a decision in a design approach. But certain relationships are regarded so important that only the most extreme decision maker in a jurisdiction called a judge is allowed to make that decision. Obviously, another way to terminate a labor agreement is based on mutual consent. So when you have a career, you change employers, that is based on mutual consent. That's always good. And what is the snag in labor law in this procedure? That is article in the Netherlands 673 paragraph 1, that around that decision of the termination of the labor agreement, the judge can order one of the parties to pay a severance pay, a compensation pay, a amount of money, normally to the employee. And that is thinking in terms of agency problems, a solution to the agency problem, as in that you quantify the problem, you translate the problem to amount of money, and you pay the principal that amount of money. In our story now, the employee. So that is how, theoretically speaking, you can connect those two worlds. So dismissal law is just the core theme in labor law, and those are quick and dirty rules, which you can in any jurisdiction Google, because there are roughly 6.7 billion employees on the globe. So there are quite a few, including you and me, who are having an interest in this type of legislation. So in each country you can Google dismissal, and then there are all kinds of arrangements. And in the European Union, or at least in the Netherlands and a few other countries surrounding the Netherlands, but also in the United States, in selected states, there are these sort of ultimate consequences. Passing the dismissal decision, you move to the severance pay arrangement. That produces case law. Case law that indicates in which type of situation employees get what type of money. The case law is, if the employer is almost bankrupt and there's no money, and certain procedures are followed, then the severance pay is up to 0. That's one side of the spectrum. The other side of the spectrum is an employer that sexually harassed the employee, then it's the highest peak in severance pay. Because then the interests of the principal are mistreated to a maximum, and that is then translated, the agency problem, translated to amount of money. So that is how you, on a spectrum, you can plot the theme employee, principal, employee protection through the mechanisms of dismissal law, which by jurists is called labor law. It has nothing to do with corporations, lawyers think. Although all those employees work at corporations. So that's why it is part of this course. And if there is such a thing as case law, which for those actors in the case is exposed, from that moment on, that is ex ante for new actors. So, if the other way to get out of employment is on mutual consent, you can agree on the severance pay in your agreement to terminate the employment with your employer when the corporation pays you a certain severance pay. And then on paper, you do not need the judge. because then ex ante, you know, if I'm sexually harassed, give me 3 million as the employees of KPMG got, or give me 500 if you're bankrupt anyhow, and okay, bad luck. And then for Dutch audiences and German audiences and French audiences, I have to mention another theme which is not related to this course. And that is social security law. That is completely different story. That is the social parachute system in a society that you can get unemployment pay. So when you're unemployed, there's a scheme, public money scheme, to give you certain allowances to survive. Which is fine, which is called social security, all kinds of names in that direction. And then something funny happens. That scheme regards you as avoidable unemployed if you voluntarily leave your employer. And then you do not get your social security payments. And only for that reason, employers and employees play a little theater, one way or the other, in certain jurisdictions, to pretend that it's not the fault of the employee that he or she is unemployed. And burdening the system, even that the severance pay is in the level you could know based on the case law, ex ante. And then they make that theater so that there's a judgment or another organ stating he or she is unemployed and it's not him or her fault. And then you get your social security system payments. But that is an anomaly in terms of theoretical practice. Because you have labor law, you have corporate law, and then you have this funny thing called social security that is sort of interfering. But that is, from a theoretical perspective, not very interesting. For practical purposes, it's quite interesting. If you are threatened to be dismissed, make sure that you Google in the jurisdiction where you're active whether your employer is following the correct rules. Don't get me wrong, but from a theoretical perspective, that is less interesting. Just to add some quick and dirty rules, let's call that business law. How does it work? As a YouTube film, how do I get dismissed in a proper way or with good severance pay and the like. The nice thing is that it is another example how law and such a clause on severance pay and the case law resulting from it influences ex ante the behavior of stakeholders. And we said that, for instance, bankruptcy law is influencing stakeholders around the corporation to act in a certain way so that there is no bankruptcy. With decision rights, prior to the break, we said the rule that decisions are invalid unless you involve the work council is a nice incentive to involve the work council. The rule to be forced to pay severance pay is a nice incentive to voluntarily pay the severance pays, the amounts due to the employee. And those are just examples that are, in economist terms, are tools to reduce transaction costs. Nothing more. Just to make the whole mechanism efficient. And that is the nice thing of a course in this minor, that we can touch upon a few quick and dirty rules just to enhance your sort of practical knowledge about running a corporation in legal terms. And this links to the theories up to and including transaction costs. Another big theme in multinational enterprises involved in purchasing and selling daughter companies. And half of you will spend half of your life purchasing and selling daughter companies. And pertaining to employees, there's this huge rule, especially in the European Union, based on a regulation that is not mentioned on the slide, but just the implementation in the Dutch Civil Code, Article 663, where it says that if you purchase, and we mentioned this already in week 3, but just to repeat it in the framework of labor law, that if you purchase the assets, including customers, of a certain enterprise, so not a share deal but a asset deal, remember, week 3, that you then automatically by law get the corresponding employees. This is the anti-cherry picking rule, that you're not allowed as buyer of an enterprise to purchase the nice parts, you know, the machines and the client list, and not the not nice parts, you know, all those old nagging employees with too high salary and you want to bring the whole thing to China and stories like that. So this is a other cornerstone within labor law. Dismissal laws, the cornerstone, co-determination is the cornerstone, and this transition of enterprise rules. So that is nice to discuss or to mention. It's another quick and dirty rule, but it ties in nicely with the theme of transformation. You know, daughter companies changing identity, changing not shareholdership, but then the assets are changing identity, and that there's a intervention by the jurisdiction by stating, by the way, you get all the employees as well. Dot. And you think that this is a very clear rule and that everybody in the industry of buying and selling enterprises are aware of it, but on a daily basis this rule is infringed and there's a lot of litigation on it. Stupid enough. So that is another reason to mention it, so that at your first workplace and you have to select sort of permanent education themes, and this is one, maybe you can select it to get a little bit more detail. What is then a transition? What is then defined as an enterprise? So when Monsanto is purchasing one patent of Nestle on making, you know, baby milk or whatever, is that already a transfer of an asset? So case law fills in the definition of when do we speak about a transition of an enterprise. And that's obviously not the case when you purchase one patent or one car, you know. When Shell is buying one car, a Mercedes for a board member, then that's not transition of enterprise of Mercedes to Shell, you know. That's just a car. And so there are a lot of themes around, and it's a nice standalone topic, maybe even fit for papers in later stages. If you're not finding any more interesting topic, then this could be a quite interesting topic. I promised to touch on innovation, and let's take the example of trademarks. And here we see the idea behind trademarks. Trademarks being the labeling or the identity, the colors and the names that assist consumers to identify the producer. So we have the functionality of a bag, and then we have Jumbo Albert Heijn bags, 25 cents, and you have Louis Vuitton bags of 5,000 euro and more. And because of the name, the trademark Louis Vuitton, you're willing to pay $3,000 instead of 25 cents. So that is the essence of trademarks. Because the name promises quality and all kinds of other things. And in the marketplace, with supply and demand and competing enterprises. There's nothing that triggers the inspiration of competitors more than trying to get a free ride with famous trademarks. And on the left side, you see a few examples. What does it say? Feels like Coca-Cola, but it's Chica Loca. Feels like Starbucks, but it is Starpreya. Feels like ExxonMobil, but it's something else. On a daily basis, people not having the diplomas of your school, who are still end up as enterprise because that's a free profession. They don't want to invent their own trademark, but they just copy. How stupid can you be? Well, and what is trademark? Trademark is nothing more than a legal right, intellectual property right. It's called a exclusive right, and in the European Union it's regulated by regulation, and in the United States it's regulated by federal law, and it's even in the Constitution of the United States, Article 8, Paragraph 8 of the United States Constitution. It's a beautiful justification of intellectual property rights, because it says, speaking by heart, to foster the entrepreneurial climate in our country. We talk about 1789, so 2.5 centuries ago. We allow the Senate to create rules to give patents and trademarks and copyrights to entrepreneurs. That's sort of the phrase in the Constitution. And so the idea is, I want to offer, as a jurisdiction, as a state, I want to offer creative minds a appreciation, a compensation for its creativity by allowing such a inventor a exclusive right, and it allows the proprietor, so the owner of the right, it's entitled to prevent all third parties, not having its consent, from using it in the course of trade. So here I'm using trademarks in the course of education. So that's allowed. But if I put Chica Loca on a dark, sweet drink, then Coca-Cola says, I don't like that. And this is a beautiful example, in my view, of piece of legislation, because the international trademarks, globally, it's called the Convention of Madrid, the European harmonization tool, the regulation, and local law all use the same wording to define the rights and entitlements of the trademark owner. And in terms of successful legislation, I think this is the most successful legislation in terms of wording, because in 25 lines you get the whole story. And in most of the cases, like with copyright, with labor law, with corporate law, it's not on one page. Think of the Chinese corporate law. On page 1 it says something about legal person, and on page 27 about delegated management, and on page 55 on another theme. And this is one of the rare examples where the essence of the trademark and what your rights and effects are in one clause. And that is what I like. And that is also what I inspire you when you draft contracts and stuff like that, to think of the option to make it 600 pages with definitions on page 1 and the beef of it on page 310, or to consider this example that you say, okay, maybe in one clause I can catch the essence of the rights and obligations of this piece of legislation or contracting or the like. And then using the other 99 pages to do some details. And this is one of those rare examples where legislators managed to put it on one page or in one clause even. So that is why I like trademarks, but obviously also because of everybody knows trademarks, and it's more accessible for laypersons than patents, because it's a little bit more complicated to understand, and copyrights and the like. So, moving to the last topic from my side, and that is the fourth domain on top of the 5 core characteristics. And when you count 5 plus 4, then you get the number 9. So anything not being assets and finance and workers and employees and production and sales is most likely regulation and compliance. That is quite relevant because the other half of the group will work in regulation and compliance. And regulation is the role of the state and compliance is the role of the enterprise. And this basically says, in a nutshell, that enterprises have to comply with the law. So that is not new. But the modern regulation is not one-dimensional anymore, because it's, with all those strategies and all those soft regulation and soft rules and corporate social responsibility of next week and all kinds of other considerations, that the simple task to comply with the law requires sort of brains, requires employees who are then called compliance officers and all kinds of flavors around it, to get the head of the company around the question, what are our obligations and how can we comply with them? That's one side. The other side is that regulators, so executive branch state officials who enforce rules, they are more and more enforcing these rules in a sort of interaction with the regulatory, the enterprise being the victim of the regulation. And one of the example sectors that is most striking in this respect are the financial institutions. And what I talk about is that compliance officers from financial institutions need to send information to the regulator, to the Financial Supervisory Board, which is a state organ, or even a federal organ in the EU and in the United States, information on the balance sheet, the amount of clients, anti-money laundering efforts, etc., etc., etc. And when they do not send in the correct information or design their internal procedures in a proper way, these institutions get fines. That is what you read in the newspaper. And that is part of this domain, regulation and compliance. That's one. Two, there are theories around regulation and compliance. And just to share that with you as a sort of last theme, and that is that if you take a life cycle approach, then it starts with market failure. The whole reason that a jurisdiction, a state, is interested in regulation and consequently in compliance and compliance officers is the theme market failure. Market failure as in that there is money laundering, or that banks fail and then economies are threatened to stay within the financial sphere. Then the second step is to decide as a state, as a jurisdiction, that public action, a public response is needed. Because the alternative is a private response. So if your bank fail, sue them. If you have damage because of money laundering, sue the culprit. But private litigation is lengthy, costly, and most likely people do not bother. And then your market failure continues to exist. So step 2 is public choice. Then step 3 is the design of regulatory strategies. Legal norms, ex ante, ex post, what have you. Then you have the establishment of regulators. Think of central banks. So you could say money is a private affair. Market, make your own money. Think of Bitcoin, think of these Facebook currencies, you know. So markets are able to invent money. But then you might have market failure. And so the old cultures in Babylonia already discovered market failure, and they said money is a state affair. And we are so used to it that we think of money as a state affair, but it's a choice. And then you need a regulator, a central bank, to manage the money. Or when we talk about drugs, so medicine, then you need a regulator that says medicine is okay, medicine is not okay. Or where it comes to animal welfare, we have an agency that is checking animal welfare at meat production plants, etc. Regulators. And then, if there are regulators potentially knocking on the door of enterprises, enterprises appoint an employee in the role of compliance officer as the counterpart of the regulator. So that the board member or the cashier or another employee, when the regulator's on the door, is not sort of, oh, hello, what are you coming to do? No, that a compliance officer with all kinds of trainings, how to deal with regulators, is sort of responding to these state officials. So here you have state enterprise. And then you have potentially sanctions, fines, warning letters, revocation of licenses. If you bring in poison drugs into a market, then you lose your license as a drug manufacturer, etc., etc. And then you have obviously judicial review, so the judge who can adjudicate whether the sanction or the intervention of regulators is sort of justified in the framework of the law, etc., etc. And there's evolution, because scholars and the market actors reflect on this whole mechanism, and then it changes the mechanism. And there are two emotions. One is from the entrepreneurs who represent the emotion, we don't want regulation. And then there's the emotion of society. When something happens, we want regulation. Then, you know, with fireworks in Enschede, there was a sort of explosion, and then the society said, we should regulate this. Where the private choice is, sue the company that exploded and get a new home and get on with your life. No, no, no. Societies and politicians crave for regulation, and that is sort of battle, and you will be part of that interaction. And evaluation should not focus on emotion, but on the market failure. What are we trying to solve? Similar to the agency problem, which could be seen as a market failure, and from an extreme hypothetical point of view, you could say that corporate law is just one of the regulatory frameworks to avoid market failure in the form of a agent principal problem. But it's not necessary to to, as a sort of von Münchhausen, frame the whole story based on the 9th chapter, but theoretically that is possible. And one of the more popular themes in master programs are related to something with regulation and compliance. Because we all agree, even without a degree in economics, that too much market regulation is hampering gross domestic product. If half of the employees are busy filling forms, then those employees are not producing goods and services. So that's the story. But without, you get a sort of messy story. This slide we will skip. That is chapter 8 on the security markets as an example where there's highly sophisticated regulatory mechanisms in the sphere of regulated markets. But let's skip that for this course, with the exception of one quick and dirty rule to close the circle with corporate law. And basically the first step of a corporation, equity finance, and that is initial public offering. And basically, in the United States, because this is the Security Act of 1933 of the United States, federal law, but the European Union has the same package. It says you're not allowed to sell shares as a corporation, to initiate shares, initial public offering, without a prospectus. So we looked at prospectus from the angle of affiliation strategies, remember, where prior to affiliate yourself with a corporation as a shareholder, you need information, and on the basis of that information you say, I want these shares or not. And at the end of the story, in a domain called regulation and compliance, we meet a quick and dirty rule that says no shares sold without a prospectus. And there you see how theory meets quick and dirty business rules. And those of you who were busy in selling and purchasing corporations, what you actually make between 9 and 5 are prospectuses. Brochures on the risks and the insights of the corporation for sale. And what I would love, and I'm closing with that wish, that you do in your future prospectuses, or the tool with which you answer the affiliation strategy of your jurisdiction, is that you bring in some systematics in your prospectus. And that you, the most extreme form would be, deal with 5 core characteristics and 4 additional domains to structure the information of your prospectus so that you cover all the practical but also theoretical themes, so that you satisfy buyers who have an interest in thinking and buyers who have an interest in tell me what I need to do and then I get the profit out of your shares, return on investment. And so that is how the last branch brings us back to the first topic, basically that a corporation is identified as an entity of which the capital is divided in shares, and then you need equity financiers to purchase these shares, because then you have assets in your enterprise. And that is how the whole story comes to an end. Page 89 is mandatory reading and exam tip number, I don't know the number. I mentioned already the guest lecture on corporate social responsibility, which will also be exam stuff, and then we will meet presenters and others during the workshops in which we will reflect on these topics, and the same applies for next week. And maybe next week, Thursday, will be a sort of exam prep because then there are only one or two presenters, so not this week but next week. So there's time for exam questions, exam prep, recap, and all kinds of other stuff. Develop some questions for that session, and I hope for the video that you liked sort of this storyline, and in the feedback give me some tips on that storyline and the bits and pieces and the balance between theory and quick and dirty rules, the paper and the presentation. See you Thursday. Thank you very much.